regarding the pattern of this particular session would be same. And since those who are new to this particular session, let me just quickly tell you the format. That you will see certain amount of questions on the MCQ format where you need to answer the same. In the end of each and every question, we'll try to give you a correct explanation along with we'll tell you how you need to approach that particular question. So I hope everybody is excited. And since this is a free live mock practice for you all, so avail this opportunity at large. So also in the end of the session, we'll declare our top three winners for the session. And let's get started. And so today, as a quiz organizers, we have with us Jyoti Singh. She is a course anchor for 𝗍𝗍𝗃 and associate at LawSikho. Along with Sakshi Jaiswal, she is a project associate and course anchor for 𝗏𝗃𝗃. So I welcome you both. And before we start our session today, please tell our participants that how many questions we'll be having for today's session and the time allotment, along with the small rules and regulations. Over to you, Jyoti.
Okay, thank you, Anu, for the introduction. Hi, everyone. So welcome to another session in the series of live mocks that we have been conducting with regard to the judiciary exams. Now, the topics for today, or rather the subjects for today, are two of the most, you can say, technical yet very important subjects so far as your judiciary exams are concerned, right? The Indian Contract and the Specific Relief Act. Now, before I tell you the scheme for this session, I would just like to give you a brief idea of, the importance of these subjects in your concerned state judiciaries. Now, these two subjects, the most, the maximum you can actually do with regard to these subjects is, number one, know your Bare Act inside out, and secondly, just know the few landmark judgments which are there on, the different aspects. Like, for example, on in case of a minor, the case of 𝗏𝗍𝗶𝗃 judgment, so on and so forth, right? So, and another major thing as far as these acts are concerned is that the number of questions that can actually be asked from these two acts would actually be very limited in nature. So if you know your Bare Act inside out, if you are well versed with the language of the Bare Act, and you are aware of the illustrations that the various provisions of the act contain, you are more than set to, be able to answer these questions in a very effective manner. Now, having said that, the scheme of this session would be something like this. There are a total of 30 questions, 20 from the Indian Contract Act and 10 from the Specific Relief Act. Now, of those 20 questions, 50 of the Indian Contract Act, I would be asking you the first 15 questions, and the remaining 15 would be asked by my friend Sakshi over here. You would be getting a total of 1 minute to answer every question, and that 1 minute would actually start from the time I read out a particular question. Okay, so I hope there is no issue with this. And with that being said, let's just begin with our session today. Okay, all the best, everyone. I'll just share my screen.
Right. There's one more announcement which I, keep telling everybody. Like when you answer your particular question, please mention the question number. And this rules and regulation are same for my Zoom live participants as well as my YouTube channel viewers. So, like you have to mention the question number along with the answer, and two answers for the same question will not be applicable. So let's start it.
Okay. So the very first question here is, when is the communication of proposals, the acceptance of proposal, and the revocation of proposals deemed to be made? The first option, only on clear verbal communication of such proposal, acceptance or revocation. Option B, by any act or omission of the party by which he intends to communicate such proposal, acceptance or revocation, or which has the effect of communicating it. The third one, only when the proposal, acceptance or revocation of the proposal is recorded in writing. And option 4, only when the proposal, acceptance or revocation of the proposal is received and understood by the other party receiving the information. Come on, guys. This is an easy one, I guess. We would not be considering the answers that are received after the time limit is over, okay? Okay, time's up, guys. So the correct answer for this question would be option number B. The reason being, this question has actually been picked up from the language of Section 3 of the Indian Contract Act, which deals with the communication, acceptance, and revocation of proposals. So guys, the area or the part of the provision which I have highlighted in red is actually the area from which this question has actually been picked up. Okay, so if you read this, I'll just be reading this and you would be getting your answer from this itself. So the communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptances respectively are deemed to be made by any act or omission of the party that is proposing, accepting, or revoking, by which he intends to communicate such proposal, acceptance, or revocation, or which has the effect of communicating it. So all of you who had answered answer D can now understand why that option is not the correct one and why option B would be correct, because this has been directly picked up from the language of the Bare Act, and our approach towards solving any particular answer should be that we pick the option that is either the exact definition of the Bare Act, or if we cannot find an option that is exactly the language of the Bare Act, then the one that is the most similar to it. So because in this one we had an option that was actually the language of the Bare Act, we went with option B.
Right.
Okay. Moving on to the next one. Which of the following is not a necessary feature to convert a proposal into a promise? Now, before I even read out the options, be very careful with the options that are given here. Okay, that's a hint in itself. Option number A, the acceptance must be absolute. Option number B, the acceptance must be within the prescribed time limit. Option C, the acceptance must be unqualified. And option D, the acceptance must be expressed in some usual or reasonable manner. Be very careful with the language.
Try to mention the question number.
This is a bit tricky if you are unaware of the language of the Bare Act.
Last 5 seconds remaining.
Okay.
And the time is up.
Okay, guys, I hope most of you have answered this correctly. So the answer to this question is actually option number B. That is, the acceptance must be made within the prescribed time limit. Now, the reason, see, all 4 of these options are actually necessary when it comes to an acceptance that is made in case of a contract. But there is now in this one, we actually need to go through the process of negation. Why? Because when you read the language of Section 7 of the Indian Contract Act, see, I have again highlighted the relevant areas here. So the first subsection of Section 7, what does it say? That in order to convert a proposal into a promise, the acceptance must, number 1, subsection 1, be absolute and unqualified. So this, if I'm not wrong, was option number 1 and option A and option C. So you can actually negate these out, that these are essential for an acceptance to convert a proposal into a promise. The next one, subsection 2, the acceptance must be expressed in some usual and reasonable manner, unless the proposal itself specifies the manner in which it is to be accepted. So if you see here, these 3 have actually been specified in the act itself, right? So because of this very reason, these 3 are absolutely essential for a proposal to be converted into a promise. And by following this, by going through the concept of negation, we'll arrive at the conclusion that option B would be the correct answer in case of question number 2. So I hope the answer here was clear, and the way to come to it was also understood by you all. Okay, moving on to the third question. Which of the following features is not essential for a contract? Remember, read the question very carefully, because we are often confused between essential and not essential. We tend to ignore the word not. Okay, so the question here is, which of the following features is not essential for a contract? Number 1, it should be in writing only. Option B, free consent of parties competent to contract. Option C, lawful consideration and with a lawful object. And option D, it should not be declared void expressly. Okay, this is a very easy question. So I guess the time's up here, right? Now the answer here is obviously, as most of you have answered correctly, option A, because it's not necessary for a contract to be in writing. It can also be an oral contract. We are not going into the details of, you know, particular kinds of contracts that must be in writing, but by the general trend. So if you go through all the other options of this question where, you know, mandatory conditions to be followed, and they were given under section 10 of the act. Okay, so I don't think a lot of explanation is actually needed over here. Option A is the correct answer, and I can see that most of you have answered it correctly, right? Moving on to the next question. Just a second. Which of the following statements is correct with regard to, now again, is correct, not incorrect, okay? Correct with regard to the termination of agency in which the agent himself has an interest in the subject matter. Option A, such an agency can be terminated by the principal at his own will. Okay. Option B, such an agency can be terminated on the death or insanity of the principal. Option C, such an agency cannot be terminated at all. And option D, such an agency can be terminated only upon an express contract to the said effect. This is tricky, and this is also from the direct, you know, language of the Bare Act itself. Come on, guys. Last 10 seconds, everyone. Okay, time's up. So the answer to this question, again, if people are well versed with the Bare Act, they would have gotten this correctly. The answer here is option number D. Why? Because this question was picked up from the language of section 202 of the Bare Act itself. See, I'll read it for you so that, you know, people who have actually made a mistake in answering this question would remember this in future. Termination of agency where the agent has an interest in the subject matter. So where the agent has himself an interest in the property which forms the subject matter of the agency cannot, and you need to focus on the highlighted term here, in the absence of an express contract, be terminated to the prejudice of such interest. So until and unless there is an express contract to terminate that said contract over here, the agency cannot be terminated. Okay, so this is why option number D was the correct answer to question number 4. All right, moving on. Question number 5. For the acts of a person appointed as a sub-agent by the agent without having an authority to do so, option A, the agent is responsible to the sub-agent only. Option B, the agent is responsible to the principal only. Option C, the agent is responsible to the third person only. And option D, the agent is responsible to both the principal as well as the third person. And here we are talking about the responsibility of the agent, okay, not the sub-agent. Come on, everyone. Last 10 seconds, guys. Okay, time's up, everyone. Now, the answer to this question is actually option D. Again, this has been picked up from the language of the Bare Act itself, section 193 of the Indian Contract Act. Now, two kinds of questions can actually arise here. This question was with regard to the responsibility of the agent, okay? The other question that can come from this section itself would be the responsibility of the principal altogether. So I'll read this out and you can understand why I said that two questions can actually come out from this section itself. Agent's responsibility for sub-agent appointed without authority. Now, where an agent, without having the authority to do so, has appointed a person to act as a sub-agent, then the agent stands towards such person in the relation of a principal to an agent. So basically the relation between that agent and sub-agent would be similar to that of a principal and an agent. And that agent would be responsible for his acts to whom? To both the principal as well as to the third persons. Okay, so this is the answer to this question. And the next question that can be asked from here would be, the principal is not represented by or responsible for the acts of the person so employed. So you can have another question that whether a principal is responsible for the acts of a sub-agent if the agent did not have the power to appoint a sub-agent. So in that case, the answer would be no. Principal is not responsible, and neither is the sub-agent responsible to the principal. But the agent would be responsible to both, to the principal as well as to the third parties. Okay, so I hope this answer was clear. Moving on to the next one. Just a second. Yes. Okay, so question number 6. What is the minimum consideration required to create an agency? Remember, to create an agency is what we are talking about here. Number 1, minimum of rupees 1 lakh. Number 2, like option B, minimum of rupees 1,000. Option C, minimum of rupees 10,000. And option D, the concept of consideration is not mandatory to create an agency. This is an easy one, I suppose. And also one more thing, everyone, we'll have a question and answer session towards the end of the webinar. So whatever doubts or questions you might have, we can take it up towards the end, okay? Okay, time's up, everyone. This was an easy one. The answer to this is obviously option D, because the concept of consideration, there is no legal requirement for consideration so far as the concept of agency is concerned, right? So that is why, because a lot of other things come into picture when the concept of agency is at play. Okay, so you do not because an agency can be created by a lot of other factors as well. So the concept of consideration alone is not a legal requirement so far as the creation of an agency is concerned. I hope it was clear. Can we move on to the next question, Anu? Yes. Okay. So question number 7. What is pledge? Again, an easy one. Option A, the bailment of goods as security for the payment of a debt or performance of a promise. Option B, the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the direction of the person delivering them. Option C, a contract by which one party promises to save the other from the loss caused to him by the contract, this would be conduct, okay, by the conduct of the promisor himself or by the conduct of any other person. And option D, a contract to do or not to do something if some event collateral to such contract does or does not happen. Very easy one. You don't even need, like 10 seconds to answer this. Okay, the time is done. So as most of you have answered correctly, I can see the answer to this is option A, obviously, because option B here is their definition of bailment. Option B here is the definition of bailment. Option D here is the definition of a contingent contract. And option C also is the definition of a particular concept. So you can see that, just by going through the first option itself, you can understand that, yes, this is the definition of pledge. And the pledge has been defined under section 172 of the Indian Contract Act. Now, moving on to question number 8. When a contract is breached, the party who suffers such breach shall, option A, be indemnified for the loss or damage caused to him. Option B, receive compensation for any loss or damage caused to him. Option C, be remunerated for the loss or damage caused to him. And option D, such a person shall not have any right under the Act. This is again a tricky question. And these are the kinds of questions that you can actually expect when it comes to the Delhi judiciary exams in particular. Very similar options, yet obviously one of them is the right answer. So sorry guys, wait. Okay, this is contract of indemnity. What is happening with my screen? Okay, the time's up, guys. So sorry, I'd shared the answers screen before this. So the answer to this is actually option number B, not option A. I'll explain why. Okay, so the answer here can be found under section 73 of the Indian Contract Act, which states which deals with compensation for loss or damage that is caused by a breach of contract. Okay, so whenever there is a breach of contract, the party that has suffered the breach is entitled to receive from the party who has broken the contract what? Compensation for any loss or damage that was caused to him thereby, which either neutrally arose in the usual course of things, or which the parties knew when they actually made the contract that is likely to result from a breach of it. Now, why is indemnity not the correct? Why is the first option not the correct answer over here? Because for for the party that has suffered a breach to actually avail in like to be indemnified, you need a contract of indemnity. So until and unless there is a contract of indemnity, and here we are simply dealing with the breach of contract, so the most accurate answer to this would be option B. And this is like I had said, until and unless you have been asked a specific question with regard to a specific concept altogether, you need to look for generalized answers. So in this one also, option B is obviously the most accurate answer over here. And this is why option A, that is the concept of being indemnified, would not come into picture. Okay, moving on to question number 9. What is a contract of indemnity? Again, a very easy one. I'll just read out the options quickly. Option A contract by which one party promises to save any third party from loss caused to that party by the conduct of the promiser himself or by the conduct of any other person. Option B, contract by which one party promises to provide insurance to the other in order to cover up any losses that may arise in the contract. Option C, contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person. Or option D, a contract in which one party appoints a guarantor to cover up any losses that may arise in the contract. The options here are a bit tricky. Okay, so time's up, everyone. Now, a lot of people might have been confused between, like, if you do not read the options correctly, you would be confused between option A and C. The only term that differs here is any third party, and in option C, it is to save the other. And option C is obviously the correct answer. The definition of a contract of indemnity that has been given under section 124 of the Indian Contract Act. So be very careful when you are dealing with options, because at the first glance itself, you would feel that option A is right. But it is only when you read it, with accuracy, you read it in with full concentration, that you would realize that a contract of indemnity is not to save any third party. It is to save the other person who is a part of that contract. Okay. So I hope this was clear, and I hope you would be avoiding these kinds of mistakes in future. Okay. Moving on to question number 10. Now, very easy one. Which of these contracts has three parties consisting of creditor, principal, debtor, and surety? Is it contract of indemnity, or a contract of surety, or a contract of pledge, or a contract of guarantee altogether? I don't think, we require more time than this. Okay, so time's up anyway. The answer to this is very easy. It's option number D, contract of guarantee. People who have answered contract of surety, see, surety is actually a part of the contract of guarantee itself. Okay, so when we are talking about the three parties here, these three parties are a part of the contract of guarantee itself. So see, when you read the question in the first glance, the first thing that would come to your mind without even thinking would be contract of surety. But that is where you need to, stay calm and apply your mind and point out option number D as the correct answer. Contract of surety would be incorrect. Okay. All right. These three are parties to the contract of guarantee altogether. Now, moving on to the 11th question. Now, if a person who is incapable of entering into a contract is supplied with necessaries by another person, then the latter shall, option number A, be reimbursed for such supplies by a relative of the incapable person, and that relative must be capable of contracting. Option B, be reimbursed for such supplies from the property of such incapable person. Option C, that is both A and B are correct. Or option D, not entitled to be reimbursed at all. Again, this is a technical question. You need to go by the language of the Bare Act itself. Last 10 seconds, guys. Okay, time's up. So the option C, this one, option C has actually been included to confuse you all, okay? The answer here is actually option number B. And this is again the language of section 68 of the Indian Contract Act, which is, what does it deal with? It deals with claim for necessaries supplied to person who is incapable of contracting. Okay, so basically the concept of quasi contract. So here the last line, the person who has furnished such supplies would be entitled to be reimbursed from where? From the property of such incapable person altogether. Okay, so like I said, the only thing that you need to remember in case of questions that come from Contract Act or from the Specific Relief Act is the language of the Bare Act. If you know the language of the Bare Act, it will be very difficult for for the questions to confuse you. So most of you thought that option C would be correct, because generally we have a tendency to move towards either both of them or none of them, right? But again, if you have read the provision of section 68, you would see that option B and not option C would be the correct answer. Okay, let's move on to question 12. What is the obligation of a person who has received advantage under a void agreement? Option A, he can retain the advantage received with the prior approval of the person from whom he received it. Option B, he can retain the advantage received without any prior permission from anyone. Option C, he is bound to restore it or make compensation for it to the person from whom he received it. Or option D, he is bound to restore it or make compensation for it only when a court order is passed in this behalf. Again, from the language of the Bare Act. And these are the kinds of questions, like I said, you have application-based questions, especially in your DJS exams. Okay, time's up, everyone. The answer to this is obviously option number C. And this question has been picked up from the language of section 65 of the Indian Contract Act, that deals with the obligation of persons, the obligation of a person who has received advantage under a void agreement or a contract that becomes void. Let's read it for your convenience. When an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he has received it. So if he cannot restore the benefit that he had received under that contract, then in that case he is bound to compensate that person from whom or because of whom that benefit was received. All right, I think we need like a 1 or 2 minutes break after a continuous round of say 12 questions. So we have reiterated this in our previous webinars as well. We have a judiciary workshop coming up on the 14th of December, wherein, the major problem that most of us come across whenever we even think of, appearing for judiciary exams would be कि correct strategy क्या होगी हमारी, right? How do we even start? हम preparation को start कैसे करें? अगर हमने preparation start कर दी है, how can we actually remain consistent? Consistency कैसे लाएं? Right strategy क्या होगी? I am devoting this much time to a particular act, but is it okay? Should I, study these acts altogether, या मैं कैसे पढूं? एक साथ में 2 substantive law और procedural उठाऊं, या what would be the right strategy that needs to be adopted if I want to successfully clear the exam. So these would be some of, and I'm not saying all, these would be some of the major questions, or you can say queries of yours that would be answered by our experts in that workshop itself. And those experts are actually people who have cleared multiple judiciary exams. So we, like, the best person to seek advice from would be people who have actually cleared an exam, right? So ये कुछ questions हैं जिनका answer आपको उस workshop में मिल सकता है. Besides this, you will also be getting an opportunity to take an online mock test, which would be conducted on an all India level. Now, iske do benefits hain. First, you would be able to know how an online exam is actually conducted. Now, the reason I'm saying this is important is because your MP judiciary exams are coming up, right? And unka prelims online hi conduct hota hai. So if you take this exam, if you take this mock, you would have an idea of how you will get an idea of how an online test is actually conducted, number one. Secondly, you would be able to analyze your own preparation level right now and where you stand with regard to the other aspirants on an all India level. Okay, so do check out the landing page of that workshop. I think Anu would be sharing it. Anu has already shared it on the chat. You can definitely check that out. And you also have a chat group which you can WhatsApp group which you can join if you want more updates regarding the judiciary workshop or other webinars altogether. Okay, so okay.
Yes.
Yes,
Yeah. One more announcement regarding the timelines, that the dates for our workshop has been shifted from 25th of November to 14th December, and the timing would be same, 6 p.m. to 9 p.m. And there is a prerequisite for our workshop that you need to register yourself, and we have kept a very minimal amount of 200 rupees. So also we have shared a link with you. You can go through that, and we have also shared a link with you all, our WhatsApp group, where you will find certain other updates as well. So do join that link. And now we can start with our continue with our live mock.
Okay.
Yes, Jyoti.
Okay, guys. So break is over. Let's move on to question number 13 now. All right. The question is a bit lengthy. So where persons reciprocally promise, firstly, to do certain things which are legal, and secondly, under specified circumstances, to do certain other things which are illegal. Option A, the first set of promise is a contract, but the second is a void agreement. Option B, the entire contract is void. Option C, the entire contract is valid. Or option D, the entire contract is voidable. Very easy question, everyone. I don't think we need much time in this one, right? Okay. So time's up, everyone. Let's not spend a lot of time in this question because it was very easy. The answer to this is obviously option A. And the relevant section here is section 57 of the Indian Contract Act. Again, I've highlighted the important provision, the relevant line over here, that where persons reciprocally promise, firstly, to do certain things which are legal, and secondly, under specified circumstances, to do certain things which are illegal, then the first set wherein the promise was to do certain legal things would be a contract, but the other part would be a void agreement. Okay, so very easy question, and the language was picked up from section 57 of the Indian Contract Act. Okay. Moving on to to question 14 of this session. In case of a breach of contract of sale of some rare article or thing for which there is no substitute in the market, the court may grant option A, quantum merit, option B, rescission, option C, injunction, or option D, specific performance. Again, an easy one. Okay, I don't think we need much time and the time's already up. The answer here would obviously be option D. See, the portion of the question that you need to read with full attention would be sale of some rare article or thing for which there is no substitute in the market. So in case you do not have substitute for a particular article or thing in the market, the most accurate the most accurate remedy that can be given there would be the specific performance of that contract itself, right? So from that point in view, option D and not option A would be the correct answer, right? So let's move on to the last question from my side, question number 15. Okay, so when a party to a contract fails to perform a contract within the fixed time, now the major portion of this question, when time is the essence of the contract. Option A, such a contract remains valid provided the promise is fulfilled, whether at the time of performance or later. Option B, such a contract becomes void altogether. Option C, such a contract becomes voidable at the option of the promisee. This won't be the promisee. If the intention of the parties was that time should be of the essence of the contract. Option D, such a contract becomes voidable at the option of the promisor or the promisee, and the intention of the parties does not matter. Tricky question, but an easy one as well. Okay, time's up, everyone. The answer here is, like most of you answered correctly, option C. Again, the language was section 55, which deals with cases wherein time is the essence of a contract. And let's read the language once, because this is one of those sections from which the frequency of having questions in your in different judiciary exams is relatively higher. Okay, so when a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, then the contract, or so much of it as has not been performed, becomes voidable at the option of the promisee, if the intention of the parties was that time should be the essence of the contract. So from this in mind, option C is the right answer to question number 15. So that's it from my side, guys. We'll have Sakshi dealing with the remaining 15 questions. Wait, I'll just stop sharing my screen, Sakshi. Okay.
Okay.
I hope, Sakshi, your net connection is fine, because it's already 12:42. Yes, we can start. Yes, Sakshi.
I'm just sharing my screen. Just a minute. Could you continue sharing your screen, Jyoti? You just have to give me access to, move it. Actually,
how can I give you access to move it?
Okay, just a minute. I'm almost there.
Okay. If you can't, I will.
Yes, I'm just sharing it. Just a minute. Can everybody see my screen?
Yes.
Yes, so the next question we have with us is question number 16. When two or more persons have made a joint promise, a release of one of the such joint promisors by the promise A does not discharge the other joint promisor.
Sakshi, could you please open this in a presented form?
Yes, just a minute. Just let me read through this and I will do that. Yeah. So option number A is does not discharge the other joint promisor neither does it free the joint promisors so released from responsibility to other joint promisors or other joint promisors. The discharge the other joint promisors did not free the joint promisor from responsibility to the other joint promisor or joint promisors. C. Discharges the other promisor, also frees the joint promisor so released from responsibility to the other promisors. D. At least one of is not responsible.
So participant, time's up. Sakshi, could you please tell us the correct answer?
Yes, just a minute. I'm just opening. Apologies, guys. It's just that. Yes, so the correct answer to this question is answer number A, option A, which says does not discharge the other joint promisor, neither does it free the joint promisor so released from responsibility to other joint promisor or promisors, right? So where can you find this? As has been stated again and again by Jyoti, you might have gotten confused in the various in option A and B and also C, where the language of the Bare Act in section 44 has been deferred differently. So the option number A will be correct because that talks about effective release of one of the joint promisors and specifically says that when two or more joint promisors have made a joint promise, a release of one such joint promisor by the promisee does not discharge.
Sakshi, your voice is breaking as well as there is some network issue. So participants are saying that the question was not audible, not visible. So can we cancel this question if you want? Because there was some network issue. And just let me know if everything is okay at your side.
If my voice is fine, I think you guys can tell.
Okay, we can move to the another question.
Okay, number 17, I hope it's visible to all of you. All of you can see the question. Please, if and I'll quickly read through it also. Your time has begun. What is the responsibility of the finder of goods? Is it same as a bailee? Is it same as a trustee? Or is it same as a pledgee? Or is it same as the owner? When we say owner, it means owner of those goods. And I think we're almost up with the time. Last few seconds. Yes, we're up with time. The time's up. The correct answer to this question is option number A, which will be same as that of the bailee. So where can you find this? This responsibility of finder of goods has been specifically stated under section 71 of the Indian Contract Act, which specifically states that a person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as that of a bailee. So responsibility of finder of goods will be same as that of bailee. Must remember this. This is given under section 71 of the Indian Contract Act. Moving on to the next question, which is question number 18. What is continuing guarantee? We've had a few questions on guarantee before this, so I am sure this will be an easy one. Is it a guarantee which continues even after the contract comes to an end? Is it B, a contract which shall be applicable to any other person who becomes a party to the contract? Or is it C, a guarantee which extends to a series of transactions? Or is it D, a guarantee which continues till the contract does not come to an end? Come on, guys. Very easy question. Last second remaining. And with that, your time is up. The correct answer to this question is option number C, which is a guarantee which extends to a series of transactions. So if supposedly, I'll just give you a quick example for this. You can read through this under section 129 also. We'll give you a few, one example wherein, let's say A, in consideration that B will employ C in collecting the rent of B's zamindar, promises B to be responsible for this collection of rent, right? Which is, let's say, 5,000 rupees for the due collection and payment of C of those rent. So this is a monthly thing. This will continue year after year, month after month, a series of transactions. So this will formulate a continuing guarantee between A, B, and C. I hope that's clear. Moving on to the next question, which is question number 19. What happens to a continuing guarantee in case of surety's death? Right? A, is it indemnification from the property of the surety with regard to future transactions? Is it B, revocation of the continuing guarantee with regard to future transactions? Or is it C, the continuing shall continue in the name of the surety's heirs? Or is it D, the continuing dealing? Last 10 seconds remaining, everyone. I hope I'm audible. Please let me know.
Yes, yes. The voice is breaking, but you're audible.
That I think the time's up. The correct answer to this question.
Sakshi, can you share your screen? If it's possible for you.
Sakshi has been logged out, I guess.
Yeah, she'll join.
Wait, I'll be sharing my screen. I think that's better.
And just let her, like spell the question if she wanted to. Yes. So we were on question number 19, and the correct option is option B. Yes. So let me just take a minute. Okay. By the time we can move to another question, Jyoti, and we can allot the appropriate time to them.
Okay. Has Sakshi joined in, or should I continue?
She hasn't joined yet.
Okay. So I'm giving them the next question till then. So this is the last question with regard to the Contract Act, guys. After this, the last 10 questions are on specific relief, okay? So question number 20, where a person pledges goods in which he has only a limited interest, the pledge is, option A, invalid to the extent of that interest, Or option B, the entire contract is invalid. Option C, valid to the extent of that interest. Or is it option D, that the entire contract is valid? Okay, time's up, everyone. The answer to this question would actually be option C. And again, this question has been picked up from the language of section 179 of the Indian Contract Act, that states, that deals with pledge in cases where pawner is only a limited interest. Okay, so where a person pledges goods in which he only has a limited interest, then the pledge would be valid to the extent of that interest only. Okay, so from that point in view, option C would be the correct answer. Wait. Anu, has Sakshi joined in?
Yes.
Okay. Sakshi, should
No,
I share the screen?
she hasn't joined yet. Please continue, Jyoti. She hasn't joined yet.
Okay. So the last 10 questions are on the Specific Relief Act, guys. Okay. So the first one, question number 21, specific relief can be granted for option A, enforcing individual civil rights. Okay, Sakshi is here. I'll just finish this question. Option B, enforcing penal laws. Option C, for both civil rights and penal laws. Or is it option D, neither civil rights nor penal laws? Sakshi, I think you can take it up from here.
Yes.
Okay. I'll share the screen. Okay. So I'll coordinate with you on that.
Yeah. And the time is up. The correct answer to this question is option number A, which is enforcing individual civil rights. Now, specific relief in primarily can be, utilized for enforcing individual civil rights only and not for enforcing any sort of penal laws. So this is something the name of the act itself suggests, right? So similarly, it is remedial in what sense? It is remedial for the purpose of enforcing individual rights. I hope that's clear. I think we can move on to the next question, which would be question number 22. A suit for possession of an immovable property under Section 6 of Specific Relief Act can be filed within A. 1 year of dispossession, B. 6 months of dispossession, C. Now, very straightforward question. The section has been given to you. All you need to remember is the concept that is laid down under Section 6. Please give one answer, everyone. Yes, with that, the time is up. The correct answer to this question is option number B, 6 months of dispossession. If you read section 6, which talks about suit by person dispossessed of immovable property, then under subclause 2 of the same, you will note that no suit under this section shall be brought after the expiry of 6 months. of each of these provisions because they are simply written, and I'm sure you all understand the meaning of the same. I think we can move on to the next question, which is question number 23. Question number 23 says, a suit for recovery of possession of an immovable property under Section 6 of Specific Relief Act can be filed against A. A private individual only, B. The government, C. Both private individual and a government, D. Neither A nor B. Now, all of you, please note you've already read Section 6 before this. So it's very easy that you derive your answer from there itself. And with that, the time is up. The correct answer to this, the government, if you all read through section 6, if you go further down and read subclause 2 beneath it B, clause B, then you can see that it can be filed suit for dispossession, suit by a person who is dispossessed of any sort of immovable property can be filed against the government, right? I hope that's clear, and we can move on to the next question, which is question number 24. For specific performance of a contract or this audit is to be instituted in
Attendees, the question is in front of you. Try to answer. We have some technical issue at Sakshi's part, but time is running. Jyoti, are you keeping a track of time?
Yes, I am.
Okay.
And with that, the time is up, everyone. The correct answer for this question is option A, which is 3 years. Prescribed period of limitation for specific performance of any sort of contract. Here they're talking about contract audit, but otherwise, if you look at the provisions of Limitation Act or Specific Relief Act or Indian Contract Act, the limitation will always be 3 years, right? So you must keep that in mind and not get confused by the question that's posed to you in any examination that you appear in, right? So either it will be 3 years, or there's another option which is given, is that when the plaintiff has noticed that the performance has been refused and it has been decided, let's say if no if let's say that the parties decide a timeline, right, that okay, within this much amount of time you need to file a suit, right, for specific performance, then that timeline is to be followed. And if no time has been issued, then that that timeline has to be 3 years. I hope that's clear. I think we can move on to the next question, which is question number 25. Yes. Recovery of specific immovable property is defined under what? Which of the following sections? Is it A, C, under section 10 of Sale of Goods Act, or is it none of the above? Very easy question. I don't think you will require 1 whole minute to answer this question also. Recovery of specific immovable property. Up, the correct answer. We're dealing with specific relief acts, so but obvious the correct answer is option number A, section 5 of the specific relief act. But don't think that okay, you're getting a number of specific relief act questions. It will not be so in the examination, right? The questions are all jumbled up from different subjects. So here, though we know that section 5 deals with, and because we're primarily dealing with specific relief act, you would know that it would be section 5 of specific relief act, which deals with recovery of specific immovable property. But it is must that you remember these things also, right? So I think we can move on to the, I hope it's clear to all of you. Next question is, cancellation of instrument is mentioned in A, section 8 to 25 of specific relief act, B, section 26 of specific relief act, is it C, section 31 to 33 of specific relief act, or is it D, section 36 to 42 of specific relief act? Cancellation of instrument.
Question number 26, Jyoti.
And the correct answer is, I think the time is up. The correct answer is option C, dealing with section 31 to 33 of Specific Relief Act. Now, what is cancellation of an instrument or cancellation of any document? If supposedly tomorrow your document or instrument become void or voidable due to any reason, under which a contract or a document or an instrument can be void or voidable, right? So the other party, what can the other party do? The other party can go under section 31 to 33 and file for cancellation of such instrument. I hope that's clear. So that is what 31, 32 and 33 deals primarily with: cancellation of document, cancellation of any sort of instrument which is void or voidable. I think we can move on to the next question, which is question number 27. Which section of the Specific Relief Act prohibits filing a case against the government? A, section 5, B, section 6, C, section 7, and D, section 8. Very straightforward question again. Prohibition of filing a case against the government.
And also, I think it's a repeated one.
In the start, you
so
might
try
have
to
faced a lot of questions with regards to, the language.
participants, time's up. The correct option to this particular question is option C, option B. Okay, yeah, section 6. So the explanation is in front of you, and this is also a Barrett language we have taken. We are moving to the another question, that is question number 28. The question is in front of you, and it reads as: Court's power to award compensation is provided in Specific Relief Act. So following are the options under section 20, section 21, option A and B. Option D is none of the above. Try to answer. Okay, time's up. The correct option to this particular question is option B. That is section 21, and a specific relief act straightforwardly provides the provision for the same. So the lines are in front of you. I'm giving you seconds to read this particular direct provision. Then we'll move to the another question. And also we have two more questions left. So just try to answer. Then we'll quickly declare our winners. Okay, let's move to the another question. Question number 29. And it says temporary injunction can be granted. Options are suo motu, ex parte. Third option is hearing both the parties. Option D, none of the above. Okay, time's up. The correct option to this particular question is option B. That is, what was the option B? That is ex parte. Okay, the explanation is no temporary injunction can be granted if final relief cannot be granted. So it is relevant, it is interlinked with Rule 3 of Order 39 of CPC that confers on the court a power to grant an ex parte interim injunction and has prescribed a particular procedure for passing an injunction order without notice to the other party under exceptional circumstances. I hope it is clear to everyone. So we are on our question number 30. That is the last question of the day. So question 30. Yes. This is also a straightforward question. What is true about perpetual injunction? So options are, is it a judicial process? Second option is preventive in nature. Third option is the thing prevented is a wrongful act. Option D is all of the above. This is not a direct question. This is a concept-based question. So try to answer. Sakshi, I'm unmuting you. Kindly unmute yourself if you are there. Please unmute yourself, Sakshi. Mm, I guess there is some issue at Sakshi's part. Yes. Okay, so we were on question 30, Sakshi, and I hope the time is also up. So yes, please reveal the correct answer. Yes, Sakshi.
P, which says so it is preventive in nature. Section 36, you can find this answer, which says that which talks about preventive relief primarily, statement of the court by injunction, the nature of interim, or which section do you have to go to? You have to go to section 36. One more, I think we're done with today's set of questions. One clarification that I'd like to give before we can move ahead and announce the result is that about regarding question number 23. 23 talked about, I'll just read out question number 23 if you can open it, Jyoti. So 23 talks about
Yes.
a suit for recovery. It's not. Yeah, a suit for recovery of possession of an immovable property under Section 6 of Specific Relief Act can be filed against. Here the term cannot has to be used. So I'd like to request Anu to disqualify this question. The correct answer remains B, that is the government, but the term cannot is to be used here, meaning that a suit for recovery of possession of an immovable property cannot be filed against the government. Quite a logical answer if we see, and also if we read section 6 subclause 2 subclause B, then we will see that a recovery suit for possession of immovable property cannot be filed against government. So please disqualify this question so that anybody who might have gotten it wrong can make good of their loss here. So yeah,
Right. Okay.
that is one
So
thing.
I hope everybody is clear on this note. And now I'll get back with our winners today. And now I'll request Jyoti and Sakshi to kindly take over this webinar and tell our participants, and if anybody is having query, so they can also ask.
Anu has just now shared the payment link for a lot of you that were asking regarding the workshop, which is going to take place on the 14th of December, where you will get an insight of the lots of courses, the judiciary course that LawSikho holds. So you'll get an insight, and also you will get a preparation strategy. You will be able to talk to experts, raise your queries directly with the experts, and who have actually cleared the All India the judiciary for that matter, and also other luminaries who've actually prepared judicial students from time and again. Okay. Any questions that you may have with respect to the session today, please feel free to pose your questions here. So Jagannath is asking how to master the Bear Act. So I think the best method to master a particular Bear Act is, first of all, go through the content carefully, read through. If you want to rote learn it, so understand before actually rotation. And you can also there are various other ways in which you can master uh, learning through Bear Act, and you can obviously those will also be answered in the workshop that we will hold 14th of December, right? So any other questions that you may have, please feel free to ask them here. I know it's a very common question because a lot of people do not know how to cannot get into rote learning, but there are various methods through which you can actually analyze and memorize Bear Acts or provisions of any particular act. Any other questions? A lot of law-based questions we had on our Q&A platform, which we've answered mostly.
Any other question, anyone?
Okay. So I hope everybody has asked their questions. So now we'll quickly move to our today's winners, today's session winners. So let me just take a moment to announce our today's winners, and I hope the questions were very tricky and easy as well. So we get a lot of response from our participants. So I'll first of all appreciate that each one of you participated, and it was a good session. And so let me just take a moment to announce our winners. Okay. So one second. Okay, so I have taken 4 positions for today's session because the competition was very, similar. So at the 4th position, we have 2 participants, Neha Gandhi and Anjali Pal. So congratulations, both of you. At the 3rd position, we have Preeti Upreti. So there is a minor number difference, but still she secured third position. So congratulations, Preeti. On 2nd position, we have 𝗏𝗏𝗃𝗏 Tiwari. So congratulations, 𝗏𝗏𝗃𝗏. And at the 4th position, we have 𝗏𝗏𝗃𝗏 Mittal. So congratulations, 𝗏𝗏𝗃𝗏. So this was it, and congratulations, winners, for today's live session. And I hope we have taken all the relevant questions, Jyoti.
Yes, I would like to think so because I cannot find any other question. I think Ekta Chaudhary has raised her hand, so if she wants to ask something.
Yes, please ask your question.
Ekta, please unmute yourself.
Yes, participant. Meanwhile, please share your feedback with us on the scale of 1 to 10, 1 being the lowest and 10 being the highest. Please share your feedback with us, how you find the questions and the level of questions. Okay, I guess she will. If you have any question, you can write in a chat box. We'll take that. And okay, we are getting some questions. Yes, we have received a good feedback from our participants. Did we take this question? Is contract of insurance is included under contract of indemnity? If anybody would like to answer. Sakshi?
Yeah, please. So contract of indemnity and contract of insurance are very different from each other. They will obviously hold the basic valid points, essential elements of a contract that will be same for the two, but the parties involved in a contract of insurance or a contract of indemnity are different from each other, right? They are different, but I'm sure where this question is coming from, this question is coming from when we say that contract of insurance, when we talk about contract of insurance, then a lot of times, it is for making good those losses, but there are a number of terms and conditions which are involved. Whereas in contract of indemnity, again, the provisions of the Indian Contract Act are included. In terms of insurance, the Insurance Act is included, and also various rules and regulations prepared by the IRDA, which is not included in case of the contract of indemnity, right? So they are similar but different. They are similar to each other. Both contract of insurance and contract of indemnity are similar to each other, but in certain circumstances they differ to each other because the regulatory authority of both these, I'm not talking about contract of indemnity, any regulatory authority for that, but there is a regulatory authority of insurance laws in India, so that can differ, right? So for that very point, those regulations, those various regulations which might be made for insurance can cause a difference between the two, but the basic outline of both these kinds of contracts are very similar to each other.
I
Right.
hope
Thank
I
you.
hope
Thank you,
that's clear.
Sakshi. Okay. So now I'll sign off. Thank you, participants, for joining our today's session, and thank you, Jyoti and Sakshi, for organizing such a wonderful quiz. And so now I'll sign off. Webinar executive Anu Bhatnagar. Thank you, everyone.
Thank you. Thank you, Anu. Thank you, everyone. Bye.